Welcome to Taxed and Confused, the podcast where tax administration meets real talk. We are your hosts, Lizzie and Lisa, two tax nerds on a mission to decode the rules, demystify the system, and maybe even make you laugh along the way. From tax returns to objections and everything in between, we're diving into the world where the burden of proof is on you, not the ATO. That's right, this isn't criminal law in tax. You're guilty until proven compliant. But just a quick heads up, this podcast is for educational purposes only. It's not tax advice, and it's definitely not a substitute for professional guidance tailored to your situation. So brace for bureaucracy and join us as we explore the weird, the wonky, and the wildly important world of tax admin. Because when it comes to tax, we're all a little taxed and confused. So, Lisa, in this episode, we're looking at what happens with the taxpayer and commissioner when they're in dispute and taking things to court. In particular, we're looking at the ATO being a model litigant and also the Test Case Litigation Program. So before we dive into those particular programs and positionings, let's take a step back. We're really talking about the appeals process, which really starts at with the assessment, doesn't it?
It does. You've got to, we're a self-assessment tax system, aren't we? So you have got to send in a tax return and get an assessment. And we've talked about in previous episodes about when does that assessment get triggered. But basically, we've got to have an assessment. And then, we've got to say, well, we've submitted it, so we think it's right. So the ATO then has to go, well, am I going to challenge that or not? You look at the process. They say, usually we get some sort of letter from the ATO saying, oh, we're questioning some aspect of your return. Do you want to amend it, or we could take it further? So it goes to audit and those sort of things. So we've got to do something, or maybe we choose to do nothing. But if they think it's, important enough or significant enough, or they've found something that, myself as a tax agent or the taxpayer's done incorrectly, it needs to go that way. And then we go through the system of who wins, who loses, and appeals and objections. And we go on this big pathway, potentially all the way up to Canberra to the High Court.
Yeah. So assessments, amended assessments, the objection process, the commissioner makes a decision. We then look to whether we wanted to have that decision reviewed by like the Administrative Review Tribunal. Maybe we even might skip straight to the federal court. If, depending on the outcome, we might then, or the commissioner might then appeal that decision on a matter of law to the federal court or the full federal court. And yeah, we ultimately get an outcome, and we have, whatever the decision or the outcome is that results in that, finalization. Might mean paying tax. It might mean, the tribunal reverting commissioner's decision back to the commissioner to, action that outcome. But it's going to take a long time. There's a long period between, the taxpayer disposing of some property and ultimately a final position on that disposal actually coming through, doesn't it?
Yeah, it is. And if you look at things that go through the judicial process, if you look at the income year that they're talking about and then, the final decision, you're looking at, just roughly like 7, 8, 9, maybe 10 years even sometimes with that getting the final decision through the court system, Lizzie. And I think the taxpayers really have to look at, and it's sort of what we're talking about in this episode, they've got to have pretty deep pockets to take it there unless they go through the test case funding, which we'll come to. But also think about, you've got the tax debt on foot. You've got GIC, which is now no longer deductible, as we know, that's all going to come through. You've got, cash flow and those sort of things. And don't forget that the ATO and the taxpayer and all their advisors can come into a nice little room and settle. It might be in a room. It might be, I can be flippant and say it's on a golf course, but, you get my drift, right? That can happen as well. Because I think taxpayers need to understand, one is the cost, one is the time, and the other one is the disclosures. Right? You think about, because once it goes to court. It's in the public domain, and we can read everyone's dirty laundry. We can Google them. We can find out what their Facebook pictures look like. We know all the factors. So again, we find that especially with business confidential information, there's a lot of things that we just don't know about, and it settles out of court. So you've got to allow for that aspect as well. So they're all the things that we think about when we're taking it further. And for someone who's an accountant like me and a tax agent, as soon as it goes any further than, an objection, I'm going, lawyers, please take over, because I also think that if I've done something wrong, the client is the person we have to protect, the taxpayer. So I'd much prefer that the lawyer throw me under the bus, because that's what my insurance is for. Yeah.
Yeah,
And that's how I always think about it.
yeah, and when when students are learning about the tax system, often we're looking at the legislation, we're looking at words, we're looking at very simple scenarios. Often, it takes some time to actually take that leap and look at, well, we're actually applying it to reality here. We've had recent fires, floods, all kinds of things happening around Australia that ultimately have tax implications that, get really quite messy. So when things get uncertain, a lot of detail has to be gone through. Our prior episode comparing a couple of cases looked to how really it really fell to the credibility of the particular taxpayer in question. So we're looking at those questions of fact, what happened actually in the real world, what's the evidence that supports that, so that there can be credibility established, what are the facts that have been found, the testimony, the behavior, so that the tribunal can make a decision at that point before it even, contemplates the matter of law being examined. So, did you spend blah? Did you, sell this? And then how does the tax law apply to that? So there's a lot of mess in there because tax applies to life, but it also impacts this process, also impacts other taxpayers as well. Because when there's an issue that is particularly pertinent to a broad range of taxpayers, that uncertainty between that first, action happening at the tribunal, the first finding, to it going through the courts to the High Court, there's a lot of uncertainty about how the law applies, broadly to a cohort of taxpayers, which can create a problem, not only for the taxpayers, but also for the ATO administering the law during that period, because there's a finding in the court which should be what's applied to taxpayers. But if the appeal hasn't been exhausted, the ATO is in an uncomfortable position, because if they apply the law as, for example, the tribunal or the federal court sees it temporarily, what happens if the decision flips at the High Court? They then have to unwind. And so what we'll see them doing is essentially holding course until all the appeal processes has been completed to create certainty and consistency. But again, the time period for that to occur can be really, really difficult.
So it's difficult for us to provide assurance to our clients of what's going on. And we've also got to look at it, so what you're sort of saying, a lot of times it depends. It depends on the fact pattern and all that sort of thing, right? But the ATO will always stand firm on their position until it's been exhausted all the way up to the High Court, if they get leave to take it there. Okay. And that's where it is. So there's a guidance called a decision impact statement, for example, that comes out and saying, okay, we're holding firm and this is our position. But what they'll say is, we'll hold our position at this point in time. Any new we won't make any decision on, in effect. But anything previous, we're going to stick to our guns until everything turns up. And again, it's accruing GIC and all those sort of things for the taxpayer, and uncertainty, and they don't really know where they stand until things actually fully flush out, Lizzie. And we're talking about timeframes before. The time frame is very much critical as well. All right, because you've got, we're talking about, you've got to have a notice of assessment first. So you've got the 2 and 4 year time frame, and then you're going to go, well, okay, if I am going to take it, along the administrative path first, the ART, we've got 60 days to be able to do that. Right. And then I've got a few numbers down here. And then you've got 28 days from the decision to appeal it from the administrative tribunal, and then you can have a 60-day extension. So this time frame is really, really important to get it in on time, because extension, if you miss a deadline, you've got to give a valid reason, which is our standard reasons for any sort of remission, that it's some sort of act beyond our control, and it's not that I've gone on holidays sort of thing. So it's those sort of things that have happened as well in terms of the timing.
So taking that into account, that time, like, they don't seem much, 60 days doesn't seem like a lot of time in itself, but when you add up that process at each stage, all the messy admin that essentially goes on behind the scenes, then the scheduling with the particular tribunal or court, over time, we're going to see years disappear in front of our eyes in this process.
And that's exactly why it takes that long, Lizzie. It takes, by the time we see it, it's like an eight-year time frame on that. And think about all the angst and everything that's gone through, and the uncertainty for well, it's mainly for the taxpayer, because the Commissioner of Tax is actually the big monolith, being the ATO and everything, that they can just sit there and say, well, we just want an outcome. Because don't forget as well, that's sort of a marketing tool for them, isn't it? Really, it's sort of nudge marketing, saying we're taking it to the nth degree, so therefore this is how we're going. And that's typical of cases that we know, like Addy and Bendel, that we'll talk about probably a little bit more, because they're test cases. But I think it's also interesting, Lizzie, because our next sort of question goes along the lines of, well, what's getting tested, isn't it? Really, what are we actually testing when we go to the Administrative Review Tribunal or the court system? Because it's a little bit different, isn't it?
Yeah. So for the tribunal, essentially, the tribunal's, standing in the shoes of the commissioner. So they're reapplying, they're considering those facts. That's where we can establish the facts of the particular case, and then look to how the law ought to apply in that. So re-establishing what the commissioner's already made an assessment of, and confirming whether they agree or disagree, or disagree in part only, and then revert it back to the commissioner if there needs to be some change to the original positioning.
That's how I think about the ART as well. So I sort of go, well, the ATO is going to come and review it, and then you're going to object, and then it goes to a different officer to look at the facts again, and then so it's sort of like the third independent review of the facts and the thing. So you're really standing the commissioner and commissioner's shoes. And when we look at cases, a lot of them are ART or AAT cases, because they've renamed it. Just total branding, doesn't make any difference, right? They're ones that are quite good, because there's a lot of facts in there, because that's what they're dealing with. So for us, in terms of using it in any of our learnings that we do in our educational setting, it's quite great. It's great because you can really build some sort of lovely case study around it. But that's really different to when it goes through the court system then, isn't it? So if one party wants to take it further than the administrative area, it's going to go into the judicial area, and then it's really a question of law, isn't it?
Yeah. So not like, they're essentially relying on the facts presented. They're now looking at, okay, based on those facts, has a tribunal made an error in the interpretation or the application of law to those facts? So, looking at what the law means and how it applies to that particular fact scenario. So interpreting the legislation, the precedent established from prior decisions, and looking to see whether there has been an error. So, should Section 8.1, so the general deduction provisions, does that apply here? So is it deductible under Section 8.1 based on the facts presented?
And the interpretation of, to the extent, the interpretation of derived, incurred, or using 8-1, so I should say incurred, those sort of things. And, or just before, there's a few things that, they've really got into the nitty gritty of, and, we've got some issues at the moment about the definition of the word mainly. What does mainly actually mean?
Yeah,
And will that
yeah.
get tested by the courts?
Yeah, or
And we've got the
previously
precedents and the hierarchy, haven't we, as well? So it can go up through the court system and all the way to the High Court.
Yeah, for sure. And I was just going to even link it to our prior episodes on serious hardship. So, what factors should be considered to establish serious hardship, those kind of things. But yeah, certainly that hierarchy is really important. That precedent, tribunals aren't really precedent like the court systems are. The higher the courts we go, the precedent, takes place of the lower level courts. And so it becomes really important that that these really establish broad principles of interpretation for all taxpayers where the fact pattern is consistent, or we can distinguish fact patterns so that those principles are not so relevant. So as we proceed up the level of the courts, it highlights the relevance to society, the public interest, and the importance to create certainty where there's a particular area of uncertainty. The High Court won't review or won't take on all cases.
Correct.
Those a decision from the full federal court can go to appeal to the Higher Court, but it's an application process to the Higher Court, and the Higher Court can say no. I'm not going to approve special leave for this to be the case because it's simply not, of importance to in the eyes of the High Court.
And that's what makes it really interesting as well, because once we get to the full federal court, we've got a number of judges, and you can read every judge's interpretation of the court case, can't you? And normally we get some sort of dissenting judge. And if there's a dissenting judge, there might be a chance it can go up because you've got to apply for it to go up to the High Court, for example. But, in a case like Bendel, there was no dissenting judge, but it's still gone to the High Court as well. And, you sort of wonder, well, why has that happened? And there's a few elements to that because, and it's coming down to statutory interpretation probably and exploring all the avenues. Because you've got to understand what the courts are trying to do. They're trying to give us all some certainty on how this applies to this fact pattern, because they then know the responsibility is they've created precedents by doing that.
Yeah, so it's particularly important that it's an area that the law is not yet settled, that there is a lot of uncertainty, and there's a range of taxpayers that will benefit for this. So this moves into really the ATO's role here as a model litigant. The ATO is in the position of administering the tax law, collecting the taxes from taxpayers. They're in a position of extreme power to do so, and that comes with responsibility. And part of that is, they're not going to take it, well, they ought not to take cases through or disputes through to the courts unless it's really appropriate to do so. So there is
it's not like it's a US, a court drama or anything like that. They have to be fair and honest, and they can't do all those tricky things that you see in court dramas and everything like that, Lizzie, is what I look at. And they can't have a win at all costs attitude, right? They've got to be a model litigant.
That's it. And they can't just be out there to take advantage of those that are not in the position to finance these kind of disputes. So there's formal guidance or formal obligations that the ATO has to be what's called a model litigant. They need to do the right thing. Their website, the ATO's website, talks about being the right thing, doing the right thing, I should say, being fair, having the highest professional standards when handling claims and litigations. And this stems from the Legal Services Directions 2017 that provide specifically that model litigant obligation and what that looks like. And it really begins with when they decide to go through those proceedings to the courts, tribunals, inquiries, commissions, even arbitration and alternate dispute dispute resolution processes, they all come under the umbrella of this model litigant obligation. They have to be satisfied that that litigation is a suitable approach to the circumstances. We've described already that they need to be honest and fair in their processes. They need to even keep costs to a minimum as part of this and be consistent and contemplate those alternatives before they proceed to the courts as well.
And so that sort of brings us into probably the next thing that we want to discuss, which is the test case program as well, Lizzie, because some of the cases, like I mentioned with Bendel, I've gone, why is it going to the High Court? I'm going, come on, ATO, it's you've lost by every judge and every, administrative officer, all the way through. Stephen at the moment is saying, yes, my interpretation of the law is correct. So, is there a conflict between being a model litigant and this test case program? So we're going to talk about how this test case program works, because there's been some real doozies that have gone to the High Court, if I can use that very technical term, where we know and love them, so to speak. They're really good stories. There's quite a few of cases that have gone through. Now, if any of the listeners know anything about trusts, they know Bamford, right? That's sort of the first one that I knew that went through the test case program. And then the other one, of course, is Catherine Addy, the backpacker that went through, because everyone's going, she's just a little backpacker. I think we're talking about 30 or 40K worth of taxable income, and so the tax on that is so small, Lizzie, right, as well. And everyone's looking going, model litigant, ATO, why is it going through? But it all went through the test case program. And I've already dropped the name a couple of times as well. Bendel is definitely going through the test case program, right? But again, for each of those, it was testing. If you think about it, why did the ATO why was it taken on as a test case? And we'll go through that criteria. But why was the ATO appeared not to be a model litigant? Because the courts wanted to do a testing of the law. So it was then going to be, I know we're on balance of probabilities because it's civil, but they wanted to try and make it beyond reasonable doubt, if I can mix metaphors with that. They wanted to make a high degree of certainty. Yeah, Lizzie, you know what I mean.
Yeah. So really the test case program is where funding is actually provided to the taxpayers for their legal expenses when disputing a matter with the ATO. So it enables here, the ATO describes this as being enabling the development of the precedent, and particularly for areas that are considered uncertain or are of significant interest or implication, public interest. And so this is, the taxpayer can apply for funding for this.
There's a net form.
So it's a you can put out there, if you're having a dispute, you can apply for that. Doesn't necessarily mean it's going to be accepted, and we'll talk about that in a moment. So overall, it's looking beyond the particular taxpayer that's having the dispute to that broader perspective. So looking at how we can really get this mess sorted for this particular area, because this is really worth spending the money on. So there's obviously funding criteria here. Lisa, did we want to start going through what that looks like?
Yeah, so the funding criteria, what do we got? If it's the valuation factual evidence, so where the dispute's about valuation factual evidence, where the taxpayer is trying to re-argue a set of law, or the issue is too narrow, it's probably going to get declined, so it's not going to give it that sort of thing. It's sort of funding the whole cost, isn't it, of the process, isn't it, Lizzie? Pretty much. It's not going to settle the tax and the GIC, but it's going to fund the rest of the process, isn't it?
Yeah. And so it's looking for, so there's basic criteria, which we've kind of already talked to. We're looking for something that's significant, that there's going to be legal precedent, but it's also looking at the fact that, the taxpayer has issues around the financial capacity to pursue the litigation, looking at their willingness. It's looking even at the past and present compliance history or behaviour of the taxpayer as well, which I think is quite interesting. So we've talked about that affecting all areas of the tax admin system, and even continues on here. If you're not really a good compliant, if you don't have a good history of compliance, it's probably going to impact your ability to apply for test funding. There's a good example, I think, which kind of links to what we were talking about earlier about when it hasn't been successful, when applications haven't been successful. And it's one example in the register is that it's where the client or the taxpayer has developed and subdivided land, and the question was about whether it was a mere realization or a profit-making undertaking or plan. So here the funding, the taxpayer obviously applied for the funding here, and the panel declined it because it's essentially something that would fall on or turn on the facts of the case.
Correct.
The actual law is pretty settled in this area of whether it's a mere realization or a profit-making plan or undertaking. There's really a strong amount of case law in this space. So really it comes down to the particular taxpayer's facts. And so really the benefit to the broader taxpayer community isn't really there. It's really benefiting that taxpayer themselves only. So in that case,
they just don't like the
declined.
outcome. Yeah, they're trying to fund their litigation because they want a good outcome for them. But if you look at we won't talk about Bamford because it was far too complex, but because it's too much about trust. But if you look at, Catherine Addy's case, the backpacker, and, was she going to monetary benefit from it? Well, a little bit, but it's basically, it comes down to a question of law. In other words, if you're a resident of Australia and, if you're coming in on a visa that's a backpacker visa, the anti-discrimination clause came in. So it was testing all the anti-discrimination clause between the Australian double tax agreement and the UK double tax agreement, right? So it was very much a question of law, and it had nothing to do with to her specific facts. Once she determined she was resident and she was on a visa, there's no dispute of the facts in that case, really. It was then, how did that work? And then with the Bendel case, what we're talking about there is saying, are UPEs alone or not? Really, that's really what it comes down to. So is an unpaid present entitlement a loan for, Division 7A purposes? Is it payment or is it a repayment?
Yeah.
And so it's and the Bendel case is very, very common, right? Extremely common. So we're not disputing the facts. We're basically saying, can we determine whether an unpaid present entitlement is a loan or a payment? So is it going to get treated like a receivable or, or a payable, or is it going to get treated like a loan and a repayment? And that's what it comes down to. So it's very much a question of fact. And that's why, even though with the Bendel case, no judge and no administrative officer has said that the ATO is correct in their interpretation, but it's still gone to the High Court because it wants to create, this is my interpretation of it, it wants to create a precedence to say, yes, this will be definitive. Right.
And so, another area that there's an example where test case funding has been provided is even as simple as occupancy expense claims for taxpayers. So in that instance, there is a lot of uncertainty in relation to historical legal precedent, and we look at in contemporary society in Australia with hybrid ways of working through COVID and so forth. It's really shaken up how we actually do things as, from our work perspective. And so again, to have the law settled and consistent in this space, there's clearly benefit there, and that's going through to the full federal court at the moment as well. So that's
we know this, Lizzie, because it's all on the register, isn't it?
Yeah,
so it's quite interesting. We actually looked at the register because we can sort of, they usually, on the register, everyone, it basically tells you what the parameters of the case is. So if you know, you sort of go, oh, that's going, right? Because we know a little bit about it. But as soon as the case has been settled, it'll tell you it was a test case. So if under a more junior court, it's gone through and now it's going to the next level, we know that it's continuing on with the test case, don't we, Lizzie? Which is what you're talking about. Well, it's topical at the moment. An ABC employee with his occupancy costs during Lockheed D Melbourne. I mean, that's sort of, we're going through to the courts for certainty. Okay. And again, the facts are the facts. And what we're seeing, if it's going through test case, is the facts are the facts. The facts are undisputed, right? And so we're actually saying, how is the law to interpret these facts?
Yeah.
And it's for the benefit of everyone, not just that taxpayer. It can't be vexatious or something like that. And, as Lizzie said, as you said before, Lizzie, it can't benefit that taxpayer, but it may, you know what I mean? But it's not designed to help the taxpayer.
Yeah,
it's designed to help the greater good, because remember, it's getting funded by our taxpayer dollars.
For sure. So what do you think listeners should think about when it comes to tax disputes and the ATO's model litigant positioning and test case funding? Are there any final thoughts you'd like to finish on?
Yeah, I think the main thing, Lizzie, when I think about it is understand that the ATO has to be a model litigant. And if they don't appear to be, it could be because it's a test case, because it has to go the full way to the High Court if it can, right? But also I think overlay on this, that the ATO do settle a lot of disputes as well, okay? And they'll settle to get a better outcome, to not cost any court fees, because in the model litigant program, who's paying for it? It's still us taxpayer dollars, okay? But there's a lot of things as well that will get settled if they don't want to air their dirty laundry everywhere. So when we see a case, we know that it's gone somewhere that we know about. There's going to be plenty of cases that we don't even hear about, that we can only hear about with media releases from the ATO and things like that will be heavily redacted because there'll be privacy concerns with it. So I think everyone, as with everything to do with tax, especially tax administration, you've got to put it in the right perspective to determine the right result. And if you think it seems a little bit unusual, there's probably a reason for it.
That's a good point. And on that note, that's it for this episode of Taxed and Confused, where the rules are rigid, the paperwork is endless, and the burden of proof is all yours. If you enjoyed this today's deep dive into tax admin, don't forget to subscribe, leave a review, and share it with someone who's just as confused as we are. And remember, this podcast is for education and entertainment purposes only. It's not tax advice, and we're not your tax agents. Thanks for listening, and until next time, stay curious, stay compliant, and stay just a little bit taxed and confused.